Good afternoon, everybody. Thank you for joining us. We'll just give it 1 minute more as a few more people join, and then we'll get started. Right, I think we'll get going because we're a little past midday already. Welcome, thank you for joining us on this online course, Mastering Long-Term Care and Funding Challenges, How to Deliver the Best Advice in Private Client Practice with Cate Searle from Searle Solicitors. This is one of a number of sessions on the Surrey Law Society's training and events programme. Tomorrow we also have a free webinar for all Surrey Law Society members on strategic financial planning. That's from 12:30 till 1:30. And then tomorrow evening, our Past Presidents Championship Cup at Daytona Sandown Park. We're then going to have a break over the summer holidays and resume training from September with another supporting Surrey session on freedom financial planning on the 5th of September. You can view the full programme of Surrey Law Society training and events at surreylawsociety.org.uk. Just a few housekeeping notes before I hand over to Cate. There's going to be a 5-minute break at around 1 p.m. If you'd like to ask a question during the session, you can type this into the Q&A box at any time and Cate will address them as and when they come in. Alternatively, if you'd like to speak at the end of the session directly to Cate, if you raise your hand, either Eloise or I will unmute you so that you can talk directly to Cate. As you've probably seen, the course is being recorded and you will be sent the recording afterwards. With that recording, you will also be asked to provide some feedback, and we'd be ever so grateful if you could do this just so we can make sure that we're tailoring our programme to everything you need. I've just seen a chat, Helen, regarding sound. We'll come back to you on that via the chat box, but in the meantime, I will pass you over to Cate. Thank you, Cate.
Thank you, Helen, and thank you, Surrey Law Society, for inviting me to come and talk to you virtually as regards the issue of mastering long-term care and funding challenges, how to deliver the best advice in private practice. So I'm going to start by looking at the themes that we're going to focus upon by introducing them, and then we'll move into the nitty-gritty. As Helen said, you're very welcome to ask questions as we go along, and that's sometimes that can be more interactive and more helpful than saving them all till the end, but I don't mind whichever you prefer. So the key topics on this day before tomorrow's election, the key topics for private client advice in relation to care funding are, in my team's experience, still very much focused on what people see as the inequity, the unfairness of the social care funding rules. And of course, we have the issue of the £86,000 care cap, delay or U-turn, and we'll have a little look at that because I personally don't think it is going to come in, but I'll talk you through that. Social care funding tensions and data. Eligibility for fully funded care, so whether our client should be receiving, for example, Section 117 aftercare funding or NHS continuing healthcare funding if they're an adult, NHS young people's and children's continuing care if they're under 18. What remains very important, probably 1 in 4 of our inquiries in my community care law team are questions around care home top-up payments and when are they unlawful. So just not to do a spoiler alert, but there is research by the local government social care ombudsman, LGSCO, which establishes that 1 in 4 top-ups for care home placements are unlawful. And we've got some case studies to look at in terms of care home top-ups. Also, we're often asked to try to help people secure adequate funding for care packages at home, so where people really do not want to go into a care home. And that can be any age. So whilst I understand that a lot of private client advice is around the older client, I'm sure that many of us, and certainly my team, acts for adults of all ages, working age and pension age. And also my team does quite a lot of work around children with disabilities and getting the care packages right. I'm also always asked to talk about deprivation. So I've brought along several really good illustrations of deprivation cases that went to the Ombudsman, which I think we'll find interesting. So protecting the family silver, we sometimes refer to that. So transferred capital or assets, so we'll have a look at that. And I've also, right toward the end, decided to add some slides about end-of-life care funding. You know, not a lovely thing to talk about, but some of our clients will need to know that. So if we found yesterday, if you were listening to the news, that Boris Johnson finally turned up and said something to support his party's election bids. And so we're going to start by looking at the £86,000 care cap. Boris Johnson was an absolutely huge devotee of this. He didn't invent it. It goes all the way back to Dilnot back in 2010. But there were often front page headlines such as "Nobody should sell their home for dementia care costs." I have read that Rishi Sunak, when he was Chancellor, never approved of the £86,000 care cap. So that's interesting. So just a refresher, because I'm sure that many of us are still receiving this type of inquiry from our client. The proposal to cap the amount that any adult would ever have to pay for their long-term care needs in their lifetime at £86,000 was only ever relevant to England. The Welsh Government had not decided whether to replicate the funding reforms. It was initially due for implementation from last October 2023, and it was going to be piloted in 6 trailblazer councils from January 2023. The aim of the care cap, and why I think it will be coming up again and again over the next few years, even though it hasn't featured largely, as far as I can see, in the current political debates and manifestos. But the aim of the care cap reforms is to remove the problem of unpredictable or unlimited care costs. I have clients who are of some high net worth, but where a long stay in a care home. I'm thinking of a particular couple where she has dementia and she's been in the care home now for almost 10 years, and is coming towards having paid £800,000 for her care fees. Her husband still lives at home and has only very recently developed care needs himself. Fortunately, they're quite minor and he will remain at home. But as her attorney, he has used all of her savings and investments and her income to pay for her care. And then, unfortunately, before coming to get advice, has used some of his own. So £800,000 has been spent on her care. And obviously, this is a couple who would very much have welcomed the care cap had it been implemented at any point in the past. But due for implementation, as I said, from October 2023. The government prediction is that the number of people in care homes who receive local authority social care financial support, if and when the care cap comes in, will increase from around half to 2/3 of the care home population. To remind us, if we are talking to clients about this, and if it does come back, I will be running training on it again. So before it was frozen or delayed, I was running special sessions on the care cap for private client practitioners through MBL seminars, and I have an agreement with them that if it looks as though it's going to come in, we'll start those up again. So you can do a whole 1 or 2 hours seminar on how we need to advise our clients. But to remind us of the overview, it's only the cost of our clients' personal care or their eligible needs that will count towards the cap. So a personal budget figure is going to be crucial to the calculation of when one would reach the cap. The daily living costs, what are sometimes called the hotel costs of a care home, don't count towards the cap, and the proposal was, and if it comes in remains, a flat rate across the whole of England, £200 a week, will be what the person has to pay out of their income, and that doesn't count towards the cap. The autumn budget statement is what led the government, or resulted in the government deciding they would move the October 2023 date to October 2025, which is currently the date that it is implemented. Scheduled to be implemented. As I say, we don't know that it will be. And when they announced the delay, Jeremy Hunt, as Chancellor, announced that the delay should allow local authorities across England to deliver an extra 200,000 care packages over 2 years. I've got some data to show you that hasn't happened. So the important thing to remember about the cap is that it wouldn't pay for your clients' care home fees in full or care at home fees in full. It will only pay an amount up to their personal budget figure, which is a figure determined by the local authority as to what they believe it costs to meet our clients' needs. We're going to do some calculations when we come to the top-up case study section, but just to remind you that is the same way that the care cap would be calculated. So my client, whose wife has paid over £800,000 for her care, under the care cap, her care costs £1,200 a week. Her personal budget figure is £800 a week, and she would have to pay the £200 a week hotel daily living cost. So she would only get £800 a week towards her £1,200 a week care costs, and she would be topping up by the £200 for the daily living costs and by another £200 per week for to reflect the fact that she is in a care home that is more expensive than the local authority believes she needs in order for her needs to be met. So that's the kind of overview. If we look at some other current social care facts and figures which are relevant, it may not be that you share all of these with your clients, but we find it really helpful to have some of this data at hand when we are advising, so that our clients understand that we are absolutely very sympathetic with their concerns that the social care funding rules are unfair, and the NHS continuing healthcare funding rules are also often unfair. And it can just help to kind of manage expectations and set the scene. So on average, a self-funder will pay 41% higher care home fees for an identical room in the same care home as a person who has local authority funding. So 41% more because they are funding privately as a self-funder. It's estimated that 37% of the 372,035 care home residents in England in the year ending February 2023 were self-funders. So in the southeast, where the property values are higher, that's 47.5%, and the northeast considerably lower. A recent Age UK study has suggested that at least 1.6 million people aged 65 plus in England and Wales are living with some level of unmet need, and drilling down into that data, a lot of that unmet need is around something as basic as having a bath or having a shower. And in 2020, which is the last year that anybody has done an analysis of, unfortunately, a total of £3.1 billion was spent on top-ups for people who received public funding, local authority funding for their care home placements. £3.1 billion of top-ups paid in 1 year. The adult social care waiting list in April 2023, for some reason the April 2024 figures haven't come out yet, although it's July, was 430,000 people waiting for an assessment, a care package, a personal budget, or a review of their current package. And Health Watch report comes out every year in September. So the most recent one from September 23 tells us that there are 2 million requests every year for adult social care, which provides long-term support for over 818,000 adults in England. And Health Watch report said that in September 2023, there were 500,000 adults on waiting lists for 6 months or more. Another study by Age UK, I've said that one, sorry, forgive me, found that 1.6 million adults aged 65 plus in England are living with some level of unmet need. And that same study found that over 13,000 adults are stranded in hospital every day. 13,000 adults waiting for delayed discharge because there isn't the necessary social care provision in the community for them. And that's significantly higher than the pre-pandemic daily figure, which was in 2019, it was typically 4,500 adults bed blocking. It is not the adults' fault that they are bed blocking, that is just the phrase that is used. The more polite way of describing it is, as I said, is delayed discharge. Carers UK have estimated at the start of this year that there are approximately 5 million unpaid carers in England and Wales, and Age UK have suggested that 20% of those unpaid carers are aged 60 plus. The issue of carers has had quite a lot of attention. Ed Davey, Liberal Democrat, has brought the issue of carers and family carers up several times during the current campaign. And I have read that care provided by family members saves something like £5 billion a year to health and social services who would otherwise be meeting those care needs. And then this one I think is really important. I mentioned the local government and social care ombudsman, LGSCO, and each year they produce an annual report, and that comes out again in September. The most recent report from September 2023 found that 79% of complaints from the public about social care charges were upheld. And I think that's a staggeringly high number. That means 79% of our clients complaining were right to complain, and their social care charging had not been dealt with properly by the local authority. When you get a copy of these slides, you will see that I give you references and links and so forth, and also some ombudsman reports and also a list of my abbreviations. But I do think it's a really important figure. So if we feel that social services might have got something wrong with our client's funding decision, rather than feeling it's just unfair, then the ombudsman can't do anything about the law. They can simply deal with how that the law is put into practice by social services. But it really is worth taking a complaint for your client to the ombudsman or encouraging them to do so. So just to cover a few practicalities and formalities before we look at the hierarchy in which I would suggest you deliver your private client advice about long-term care funding. We always have to keep in mind who our client is, whether it is the person with care and support needs, if they have mental capacity to instruct us, if they want to instruct us, or whether it is their attorney or their deputy, and whether the power of attorney, if it's an enduring power of attorney, whether it's been registered. If it's a lasting power of attorney, are we being instructed by the attorney for health and welfare or the attorney for property and finance? Are they the same person, the same people? Are we being instructed by both? And what happens if there isn't a lasting power of attorney for health and welfare? And likewise, if we're instructed by a deputy, in my team, we receive a lot of instructions from professional deputies so that we can assist them with public law arguments, which may not be their forte because they're brilliant professional deputies, but they're not public lawyers, community care lawyers. And normally we will be instructed by deputies for property and finance, whether they're lay people, family members or professionals, because there are relatively few health and welfare deputy appointments. And so if we are instructed by a deputy, whether you are instructed by a deputy or you are acting as a deputy for your clients, we need to really dig through the impact of the ACC judgment, a judgment by Senior Judge Hilda of the Court of Protection, which significantly restricts the steps that a deputy, a lay deputy or a professional deputy can take in relation to things that might be considered to be welfare decisions. And one example I just want to pause on because it really is important. If you don't have ACC authority, specific authority from the court to deal with the things that fall within the judgment, the remit of the judgment, then the very strong chances you will not recover your legal costs for doing that piece of work as a deputy, or your client as the deputy may not recover the legal costs. And one of the things it might surprise you that falls within the areas for which specific authorisation must be obtained is NHS continuing healthcare appeals. So for reasons that aren't entirely clear, the judge decided that these are in effect welfare issues rather than finance issues, NHS continuing healthcare funding, whereas I think it is both welfare and finance. And if you want to appeal an ineligible decision on behalf of your client and you are a deputy or you are advising a deputy, they absolutely must have the specific authorisation required under ACC before doing that. So do keep that in mind. We also often have to think about how to act when our client has no formal authority. And I did say in the details of the course that I would share casework examples. And we have one exactly about this at the moment that I'm dealing with for a colleague whilst she's on annual leave. Our client is a man in his 80s. His wife was until last week in psychiatric hospital in London. She's under section, she has schizophrenia, she's under section 3. It's not the first time that she's been under section. And she was in hospital for around 6 months. She has never made a power of attorney, neither lasting power of attorney nor an enduring power of attorney, although we suspect that, you know, there are times when she would have had mental capacity to do so. She hasn't done it, and nor has a deputy of any type been appointed to act on her behalf. She has been discharged, instead of being discharged home, which is where her husband would like her to be, she has been discharged to a care home placement. And there is nobody there, nobody has authority, neither her husband nor her son, to deal formally with her finances or her health and welfare decision making. So we are arguing with the legal team for the NHS Hospital Trust, who at the moment are not giving us any documents. We are arguing, we're running a best interest argument under the Mental Capacity Act, obviously, that they do need to share information and documentation with her. And it's very sad, actually, because before we became involved, there was a best interest meeting to decide where, let's call her Mrs. X, where Mrs. X should be discharged to. And in fairness, there is some work that needs to be done at the marital property in order for it to be safe, because she wouldn't be able to access it. Her mobility has declined significantly. So some work needs to be done to make the home safe. But it would appear that Health and Social Services have made a best interest decision that she shouldn't go home even if the property is made safe for her. And they had a best interest meeting to which they did not invite her husband. And because we haven't seen the minutes yet, I don't know the basis upon which they excluded her husband from that best interest meeting. But that isn't acceptable. He should have been. He has a valid contribution to make, even if Health and Social Services don't agree with his view. He is one of the relevant people that they should be consulting with in relation to his wife's aftercare. And then I mentioned aftercare. So this morning, just before I came to log into this session, my client, Mr. X, we'll call him, sent me an email, and his wife has been at the care home now for 2 weeks. And I mentioned that she has been under section 117. That she's been under section 3. So in my view, she should be receiving section 117 Mental Health Act aftercare funding. And she has received a letter, which she's handed to her husband. He visits her every day and he takes food in and he helps her eat her evening meal. She's had a letter telling her that she's passed it to her husband because she can't understand it, that her care fees are £6,000 a week, and inviting her to make a contribution from her income towards those care fees. However, she should be covered by section 117 Mental Health Act aftercare funding, which is one of the topics we're going to come on to. So how to act when your client has no formal authority is difficult. And of course, as private client lawyers, you will be doing whatever you can to work with your client and their family members to make powers of attorney whilst they have mental capacity to do so that we don't end up in the kind of messy situation that Mr. and Mrs. X are finding themselves in now. I mentioned also stopgap measures pending deputyship or LPA or EPA registration. Just a reminder, really, that your client can apply to be their family member's Department of Work and Pension appointee, which would allow them at least to receive their state pension, their universal credit if they're working age still, their disability benefits, so PIP, DLA or attendance allowance, whilst you wait for the deputyship appointment or the LPA registration. So it's always worth remembering, while that doesn't give them access to the assets of the bank account because that needs proper authority, they will at least be able to receive on behalf of their loved one the basic benefit income, which would then allow basic needs to be met. The other practicality and formality, I don't know how often this arises in your filing cabinets, but in my team's filing cabinets, it's very, very common. Sibling disputes and particularly where those siblings are attorneys or deputies, how to work your way around potential conflicts of interest in a long-term care funding situation. Okay, so those are the things we're going to look at. And the hierarchy that we use in my team when we're giving funding advice is we first look at whether our client should have their care fully funded before we go on to look at the other rules. And so the first thing we would look at, as I said, about Mr. and Mrs. X is the client's eligibility for Section 117 Mental Health Act aftercare funding. You deal with that, in my view, first before you look at NHS continuing healthcare funding, because 117 is significantly easier to access if your client is eligible. We'll look at the eligibility criteria in a minute. And if it's easier, it also means you're doing far less legal work. So it's a more cost-efficient legal process for your client. If 117 doesn't apply to your client, we would then look at the NHS Continuing Healthcare Fast Track Pathway. And if that isn't relevant, we would then look at NHS Continuing Healthcare for an adult or, as I said, children and young persons continuing care if they are a child. And then if none of those apply, we would then look at the funding options when our client can't qualify for fully funded care. So those briefly, and we will dig into them. NHS funded nursing care, which is a payment made to the care home if the care home is registered for nursing. The current rate is 23588 per week. And the issue there is whether our client will feel the benefit of that payment or not. So does the care home contract provide for our client to be given credit of that amount, so it's knocked off their care fee, or is it included within the care fee, so it's gross, so the care home say that they don't have any duty to deduct the payment made by the NHS from our client's care fees. That's all about contract, and I will come to some references where you can have a look at the Competition Market Authority's guidance on that. So we've got NHS funded nursing care, we've got social services means testing, we've got social services property disregards, and then we've got personal injury trusts and settlements and the rules for income and capital. So before we look at Section 117, just a reminder that there is no guarantee of lifetime funding, and I'm sure that everybody who's joined the webinar today is aware of that. Unfortunately, many of our clients aren't aware of that. And it becomes very important, I think, particularly for people who do get NHS funding. So they or their relative has got NHS funding, possibly they've got fast track funding. Typical scenario, the person is in hospital, let's call her Kate. So Kate is in hospital, Kate's a pensioner. The hospital consider Kate to be ready, medically optimised for discharge. Decisions have been made, whether by the attorneys or by the best interest decision maker, health or social services, that Kate needs to go to a care home, and she appears to have a rapidly deteriorating condition, so she's given fast track funding by the NHS. So fast track funding will normally fully fund the care home placement for a period of 3 months, at which point it is then reviewed, and if the person is no longer considered to be in a rapidly deteriorating condition, a potentially end of life care situation, then the funding, like the fast track funding, is withdrawn and an ordinary continuing healthcare assessment, eligibility assessment, is undertaken. Quite often, the NHS forget to come back at 3 months and the funding remains in place. So a year might go on or 2 years might go on. And so our client's family get a real shock when they receive a letter telling them that the NHS is no longer paying. The person has outlived their diagnosis, or their prognosis rather, and they're not eligible for ordinary NHS continuing healthcare. And by then, a whole series of actions may have been taken by the attorneys, including, we often get these cases come to us because there's been gifting, transfer of property title into the names of adult attorney children, etc., etc. And the assets are no longer there to pay for the person's care. So there is no such thing as a lifetime guarantee of any statutory funding award. In terms of Section 117, it can be quite hard to lose 117 eligibility, but it's not impossible. In terms of NHS continuing healthcare, whether that's fast track, whether it's standard NHS continuing healthcare, or whether it's what during the pandemic we called discharge to assess. It's now got all sorts of different names, but they in intermediate pathway planning, funding, etc. Any NHS funding that is put in place is not lifetime guaranteed, and our clients really need to understand that before they start dividing out the assets that will be needed to pay for the person's care once the NHS funding has been withdrawn. So to go back and dig in, fully funded Section 117 aftercare. So that's Section 117 of the Mental Health Act 1983, and the provisions are relevant in England and Wales. Aftercare services are defined in Section 1176 of the Act as amended, and an aftercare service is defined as meeting a need arising from or related to the person's mental disorder, and a service that is capable of reducing the risk of a deterioration of the person's mental condition, therefore hopefully reducing the risk of them requiring a further hospital admission. So law and guidance make it absolutely clear that the local authority must not charge for Section 117 aftercare. I've given you the where you'll find that within the CNSSG. So with my slides, you'll also get a list of abbreviations. CNSSG is the Care and Support Statutory Guidance, hugely useful resource, around 500 pages. So it's very clear that the local authority mustn't charge for Section 117 aftercare. If it's a joint local authority and healthcare package, the NHS can't charge anyway. So the question that we're asking ourselves, not necessarily asking our client in the advice process, because it may not be relevant to them. So by no means am I suggesting that we take all of our clients through the 117 process. It's really, we're thinking about it ourselves. Was our client detained in psychiatric hospital under one of the Mental Health Act treatment sections? So that will usually be Section 3. It could be Section 37. Section 37 is a forensic section. If we find evidence that now or at some point in the past our client was under Section 3, then we are asking ourselves, is it the same mental health condition that now results in our client requiring aftercare, whether they have that care provided for them at home or in a care home or in a nursing home? So if it is their psychiatric condition that results in their aftercare needs and they were under Section 3, then we should be making sure that they have Section 117 funding. So I will be, I've already written to the legal team on Mrs. X's case, and I have said, please confirm that these invoices asking her to make a contribution toward her care package have been issued in error, and that she is receiving Section 117 fully funded aftercare. And I hope I will hear back from them when I get back to my desk after the session today. So we should always explore whether there were psychiatric hospital admissions, but keep in mind that if our client was in hospital under Section 2, which is a short 28-day section, which is for assessment rather than treatment, or our client was in hospital under a deprivation of liberty safeguards authorisation, neither of those things result in Section 117 aftercare eligibility. So we really do need that confirmation of Section 3 or Section 37. There has been a there have been a number of focus reports issued by either the Health Ombudsman and or the Social Care Ombudsman recently, and there's a really useful one. Again, you'll get these slides so you can follow the link yourself, all about Section 117, which I do recommend that we all read, and it highlights the following common problems in relation to Section 117. So aftercare planning delays, difficulties with the personal health budget, so how much should be paid for the person's aftercare, disputes about whether it's the local authority or the NHS who holds the aftercare duties, and then sometimes it can be disputes between different NHS trusts or different local authorities about which one of them holds the responsibility. There's quite a lot going on in relation to accommodation and aftercare. So if your client is eligible for Section 117, but is in a supported living or extra care housing facility rather than a care home, there is a strong chance that social services will say that the 117 funding will cover their cost of their care and support, but it will not cover the cost of their accommodation unless it is what they call enhanced accommodation. This course today isn't sufficiently long for me to go into detail about that, but do seek out the advice if your client is being 117 funded, but you are being told they have to pay for their accommodation. And also, what is the proper process for ending Section 117 aftercare duties? So as I said, it's not guaranteed for life, but there is a very clear process that must be followed before a decision is made that someone no longer fits within Section 117. So if we can't get a client within 117, then, as I said, we would look at the NHS continuing healthcare. Now, I have made a typo on that slide, and if you would apologise, sorry, I accept my apologies. This data is actually from Q4 2023, 2024. So this is the correct data, but I've just put Q3 instead of Q4 when I was typing the notes up. So this data runs up until 31st March 2024. And we are aware from NHS England's data that the total number of adults in the whole of England who were eligible for NHS continuing healthcare at the end of the financial year was 52,096 adults, which I consider to be a really, really small number of adults. If we think that we know from the earlier data that we've got at least 815,000 adults receiving social care funded by the local authority, and then we will have goodness knows how many hundreds of thousands of adults self-funding their social care who don't turn up in any of these data analysis, and yet only 52,096 adults funded by NHS continuing healthcare in England. And then we break that down further because only 34,055 of those adults were getting standard NHS continuing healthcare. The remainder had fast track awards. And then just another slightly gloomy figure to share. If our client is found ineligible for NHS continuing healthcare and our client instructs us to appeal to the local resolution panel at the local NHS level, the Integrated Care Board level, not only if you are acting as a deputy or advising a deputy, do you need to make sure that you've got re-ACC specific authorisation before you run that appeal. You need to be aware that the success rate is very low, which in my view has got nothing to do with the quality of the arguments put forward by family members and representatives. It has a lot to do with how unfair and uneven NHS continuing healthcare is and remains. Only 16% of eligibility appeals are successful. If you don't succeed at local resolution level, then your client may well, or the person instructing you may well want to go to NHS England independent review panel level, where the prospects of successful outcome are higher, although frustratingly, NHS England doesn't give us data on that, but I can tell you from my own team's casework that we have run a great many cases at independent review panel level that we didn't win at local resolution level. And if you don't win at independent review panel, you you're rather stuck. You either potentially have a judicial review, we'll come back to that at the end, toward the end of the session, or you go to the Parliamentary Health Service Ombudsman if there was fault by the part of NHS England, on the part of NHS England, in how they managed the appeal. I've just had a really positive outcome from the Parliamentary Health Service Ombudsman, where I absolutely believe that my client's mum is one of those relatively few adults who should qualify for continuing healthcare funding. She has a very rare type of dementia, and her behaviour at the time of the assessment was extremely challenging, both to herself and to other people, and in addition, really complicated nutritional needs, problems across all of the care domains in the decision support support tool. And the independent review panel felt that she wasn't eligible. They upheld the local decision that she was ineligible, although they did make a recommendation that the NHS should go away and think about whether they should have joint funded her with social services. So they were kind of saying, look, we don't think she's eligible for full funding, but we think she should have had more than social care funding. She wasn't social care funding, she was privately funding, and is in a placement that costs over £2,500 a week because it's a specialist neuro rehab based type placement, because of the complexity of her needs. So the Ombudsman agreed with my submissions that NHS England had made a decision that should not be sustained, and they have sent the case back to NHS England to reconsider, and given them just 6 weeks to reconsider that decision. So whereas often we can find the Health Service Ombudsman to be quite disappointing, it's always worth having a think about taking it further if you believe your client's case is strong, and if you believe that the ineligible decision is unreasonable rather than just unfair. Just to remind us then where you will find the information that you need if you're looking at a NHS continuing healthcare or children and young persons continuing care appeal. Both the English and Welsh national frameworks were revised in 2022. The timescale to appeal an ineligible decision in England is 6 months from the date of that decision letter. In Wales, it is only 28 days from the date of the decision, unless there are exceptional circumstances. And here again, just a reminder that deputies will need to seek specific authority from the Court of Protection before lodging their grounds of appeal. So if we look at the social care funding thresholds, I will correct this slide as well before they come out to you. My apologies, and put my glasses on, that might help. These are the thresholds for England and Wales in 2024-25. These are the current year thresholds. So I've just done a typo there. So if our client is resident in England, they will self-fund, whether they are at home or in a care home, if they have more than 23,250 worth of cash, savings, assets, assessable assets, etc., including property, if the property is accessible. In Wales, it's very different regime. So similar law, but different statute, but a different application as well. In Wales, our clients will only self-fund in a care home if they have more than £50,000 in assessable assets, and they will only self-fund for care at home if they have more than £24,000 in assessable assets. Okay, so the personal expense allowance that's used in England and Wales is different as well. If our client is in a care home in England, they are allowed to keep £28.25 per week of their income, and possibly an extra £6.50 per week of their income to buy the things that they need as a person in a care home. In Wales, the personal expense allowance is £35 a week. If our client is in England receiving care at home, if they have a high level of income from state pensions and benefits and or private pensions and benefits or whatever source, our client could actually be fully self-funding their care at home, even though they have assets of below 23,250 because of their high level of income. In Wales, there is a maximum contribution that the person at home cannot be asked to pay more than £100 a week towards the cost of their care at home package. So just worth knowing about those. One of the things that matters a lot to our clients and their families is whether they can obtain a property disregard when the person with care and support needs goes into a care home. So property disregards are another thing that when we're considering how to deliver the best advice in your private client practice, we always explore these property disregards. So we'll have some examples here. So the person who has gone into care, if they will receive a disregard for the value of their property. So social services will not take the value of their property into account in the financial assessment if they have a spouse, partner, or civil partner living in their home. Okay, so if we're going to use an example, I'm going to call them Frank and Violet as my grandparents' names, and I'll remember them. So let's say that we have they're both in their 80s, so we'll use a typical elderly client example. They're both in their 80s. Violet has dementia. Frank has been caring for her at home, and he can no longer manage that because he's developing his own physical care needs, and he can't manage the process of caring for her. So she moves to a care home very close by their marital home, which is relevant because we'll discuss Frank and Violet again when we talk about care home top-ups. So she is living there in the care home, and Frank is her attorney, and Frank uses up her savings paying for her care fees. And then she drops to 23,250, and he was talking to a friend who says, oh, that means you've got to sell your house now, Frank, because Violet is the half owner of the house and she'll need her money to pay for her care fees. That could be a friend saying that. It could actually be somebody in the social care team saying that. We have had social care staff telling that to our clients, and it's completely incorrect. So luckily, however, Frank remembers that you helped him make the powers of attorney, so he comes along to see you and have an appointment where he gets advice. So Violet's share of the marital home is disregarded in her financial assessment by social services because it is occupied by Frank, who is her spouse. Okay, if Frank and Violet were in a cohabiting relationship, then it would also be disregarded because it is spouse, partner, civil partner, and it is not about just being married. So Frank has been given the wrong advice. Fortunately, he has been to see you. And so he knows that he isn't going to sell the property, and you continue, or he continues with the process of getting the financial assessment. However, where you may have an issue is that Frank, as the spouse, comes to talk to you about the fact that he can't really cope in the property anymore. It's too big for him. It's got narrow stairs. It's expensive to run. And he's seen a bungalow on the same road, so also very close by Violet's care home, which again is important. And he would like to downsize. And if he downsizes to this bungalow, that will release some more cash that Violet can use to self-fund her care. So that's all looking good, but he wants to know whether social services will continue to disregard Violet's share of the bungalow if that is bought on the identical same terms as the marital home is owned. So let's say they're tenants in common. So second trustee, because Violet can't deal with the conveyancing process, she can't make the decision to sell the property or buy a new one. You're going to deal with all of that for her, or your colleagues in the conveyancing team are going to deal with all of that for her. She will be named on the property. Will social services ignore her share of the value of that new bungalow? The answer is no, not necessarily. Really, really important point here. Any of these disregards on the screen, spouse disregard, age disregard, disability disregard, they only apply to the property in which the person in care lived before they went into the care home. Okay, so you would need to ask the local authority to use their discretion to transfer the property disregard with Frank to the new bungalow. And in my view, if you're tackling this ahead, you're doing it long before contracts are exchanged. You're writing to the local authority, dear social services financial assessment team, I act for Violet, who is I act for Frank, who is the attorney of Violet. He proposes to downsize, the bungalow will be bought on identical terms. It will generate surplus sale proceeds of £100,000. So £50,000 of that, 50% of that, will be paid into Violet's power of attorney bank account, and she will become a self-funder again. Please confirm in writing that when Violet has used up that £50,000 as a self-funder, you will grant the spouse property disregard against the property. So you need to get that in writing before that move happens. The other disregards we need to keep in mind, whether these people are owners of the property or not doesn't matter. If the person in care's property is occupied by a relative of theirs who is aged over 60, or a child of theirs, not a grandchild, a child of theirs aged under 18, then there should be a property disregard. If the property is occupied by a disabled relative of any age, then the value of the property should be ignored. If our client's admission to care is temporary, then the value of their property or the value of their share in the property should be ignored. If the care home admission is regarded as a permanent care home admission, then they should have a 12-week period during which the value of the property is ignored. The folklore behind that is that 12 weeks is supposed to be long enough to give whoever is the attorney and the deputy, whoever is the decision maker, time to decide what to do, whether to get a deferred payment agreement or whether to sell the property, etc., etc. 12 weeks isn't long enough, of course. And then also to remind us that there is one discretionary disregard, which is colloquially known as the carer's disregard, although it isn't strictly only for carers. But that's the context in which we most often see it used. Again, I will give a quick example that's come in to my team this week. There is a lady living in Surrey who's in her late 70s. Her son moved in with her 3 years ago to care for her and for his father. His father has subsequently passed away. He remains caring for her. He is 57 years old. So the family think that it's probably time to start planning a care home admission for mum due to the complexity of her needs. And they've taken advice from a regulated independent financial advisor, and there are enough assets and income to pay privately for care for just over 2 years. Okay, so what they're seeking advice on is whether we think the brother will be given the carer's disregard when his mum can no longer privately pay for her care home costs. And there's just no guarantee, because it is a matter of discretion, and local authorities are cash strapped, as we know, and if social services can exercise their discretion to say no, that's what they're going to do, because they will talk about wanting to save money to the public purse. So they will probably offer a deferred payment agreement and say, look, we can loan fund the lady's care, but we're not going to ignore the value of the property. So in that case, what the family are going to do is go back to the drawing board and see if they can make the assets and income stretch out for 3 years, by which point the son will be a relative aged over 60, provided that he hasn't moved from the property. He will then the property will then be disregarded purely because of his age, and social services will be picking up the cost of paying for his mother's care home fees, subject to her income contribution, because the value of her property will be ignored, and that is how it goes. Okay. I'm not going to do a lot of detail on this, and we're coming up towards a 5-minute break, but just briefly to touch upon social care funding and personal injury awards. So a reminder that the local authority social services must disregard the lump sum capital derived from the person's personal injury award, where it's held in a PI trust and or it is managed by a deputy for property and finance. And I give you the source of that stipulation is the charging regulations, and also the reference to care and support statutory guidance. I mention this because whereas it is accepted that lump sum capital is to be ignored. It's a matter of law. The local authority, the government could have changed the law when they brought the Care Act in. Care Act 2014 came in April 2014. They didn't change the law. So whereas we know that the lump sum capital is ignored, local authorities are now trying to get hold of periodical payments and say that those can be used and should be used or must be used to pay towards the adults' social care package. And that's quite a new development. Not all local authorities are doing it, but we've come across 6 or 7 such cases in the last couple of years. So very briefly, I'll leave you to read those bits. The Tinsley case had a look at this. So this is a case where Damien Tinsley had a professional deputy. Damien Tinsley was subject to Section 3 Mental Health Act detention, so therefore he was eligible for Section 117 aftercare funding on his release from psychiatric hospital. He also had a personal injury award. Manchester City Council, his local authority, knew about the personal injury award, and they said, we don't have to pay for your Section 117 aftercare funding because you have got a personal injury award. And the deputy had no option but to take this to the High Court. He did go to the Ombudsman first of all, but the Manchester City Council wouldn't back down. So he took a judicial review to the High Court, and he won that judicial review. But Manchester City Council appealed, and it went to the Court of Appeal. Both the High Court and the Court of Appeal found against the council, and both courts ruled that Mr. Tinsley's right to Section 117 aftercare meant that his personal injury award couldn't be taken into account when arranging and funding his aftercare services. But bear in mind that this case didn't address the issue of periodic payments, so we're not really very much further forward in that.
Just drawing your attention to a question in the Q&A box, if you haven't seen it, which has just come through from Paul Masters. Would you like me to read it out to you?
Yes, please.
Is a person diagnosed with learning difficulties and Parkinson's disease who is a resident in a care home deemed to be a person who is mentally incapable? I have a client with these conditions who has signed an LPA, which he was deemed capable to sign, which contains a provision that the LPA cannot be used unless the resident loses mental capacity and the attorney is not sure the LPA can be used to help the client get his affairs in order. My initial view is that the LPA cannot be used as the client can probably be supported to make a decision.
Okay, really interesting question. Thank you, Paul. So I suppose that makes us all think, oh, I do wish people wouldn't put guidance in there. So presumably we're talking property and finance, of course, the LPA, because a health and welfare LPA can't be used unless the person has lost decision-making capacity. So I think if you would probably need to do either your own assessment, Paul, or arrange for a mental capacity assessment to be undertaken, because we've got a presumption of capacity under the Mental Capacity Act and its code, and of course any decision that we're looking at has to be decision specific. So the diagnosis isn't particularly relevant. So the diagnosis of a learning disability and dementia, I think you said, is relevant because it is that means that the person falls within the Mental Capacity Act. But the question is whether they do have the mental capacity to make the particular decision in question with support if required. So it's rather than looking at it as a whole, it's drilling down what is the actual decision that needs to be made. And unfortunately, I think an assessment is going to be required anyway. And it might be that you do want it to be an assessment by an independent social worker, or you could even ask the local authority. I wouldn't have thought the GP would do it in our experience. We're not finding GPs particularly helpful at the moment. It could be done by a psychiatrist or a psychologist, but it doesn't need to be somebody medical. We will often use independent social workers in cases such as this. And the reason I'm saying I think you're going to need a a capacity assessment in writing anyway is because if your client, the person who is appointed as the attorney, does start having to act as attorney, the chances are that the financial institutions that they're having to liaise with will look at the power of attorney document, and they'll say, look, this says that you can only act as the attorney if P is lacking mental capacity, so therefore show us that he is lacking mental capacity. So I think if your feeling is that they can decision make and you're happy to go and do that assessment yourself and make a file note, then at the moment it is, as you say, it's about giving the person support to reach those decisions themselves. And that's where you would start, because then you're not incurring the cost of the having an independent assessment. You could reach out to social services, but you could be waiting a long time, and they might also say that they don't consider it's their role to undertake that assessment. So if all else fails, then an independent assessment. I hope that kind of helps a bit. And do feel free to turn your microphone on at the end of the session and debate it further. I'm very happy to do that. Okay, so we're going to look at top-ups for care homes. Then we're going to look at care at home funding, and then we're going to look at deprivation. And then, as I say, I will be sharing these slides with Helen and Eloise to send over to you. I think I'm going to add some extra footnotes to them before they come out, so just to cover a couple of things that have come up today. So hopefully you'll be able to have those later in the week. Okay, so as I said at the beginning of the session, Age UK and the Local Government Social Care Ombudsman have published research that indicates that 1 in 4 care home top-ups are unlawful, by which I mean nobody should be paying a top-up. And we've already looked at the fact that in the year in question, which was 2020 pre-pandemic, that £3 billion was paid in top-ups by third parties or first parties. So we'll have a look at what the distinction is there. So when we are looking to deliver the best practice advice to our private clients, we look at who's going to pay the top up, first party or third party, when do they pay, how much do they pay, should a top up even apply, and we've got a case study to go through here. And then you dig down into the Care and Support Statutory Guidance. I've given you the references, and Annex A of that guidance is all about top-ups. And then there's also the Competition Market Authority's Consumer Law Guidance to Care Providers, which is really, really, it is so useful. It is really brilliant. My team is often digging down into that and taking quotes out of it and writing to care homes about charging and writing to local authorities in relation to where consumer law is being breached around a care home top-up situation. So digging in, I can't move my screen. No, hang on. Sorry, technical problem there. So digging into this, most top-ups are third-party payments, usually paid by family, sometimes paid by charities. So we have a few clients who have got top-ups funded normally by the armed services charities, RAF Benevolent Society, for example. We had a really interesting case recently where the Mine Workers Charity Association is paying a top-up. So some charities can help. Oh, and we've had a couple where it's actually Retired Actors Charity that is paying a top-up. Nonetheless, we don't want the charities to be paying top-ups if the top-up is unlawful. So we would be wanting to really look into that as well. Our client can pay a first-party top-up in certain specific circumstances. These are the only circumstances. So going back, we're going to have a look at a case study. We'll stick with Frank and Violet as well. But if you remember that when a top-up becomes relevant is when our client has less than 23,250 in assessable assets. Okay, so that maybe they never had assets and they've always had social care funding. You've looked at continuing healthcare funding, you can't get them, you can't get an eligible decision. Section 117 doesn't apply, so they come under the social care funding rules, and they either never had sufficient assets to pay privately, or they have been paying privately for a number of years, and then now down to 23,250. And the local authority comes along and assesses them and says, absolutely, let's move it back to Violet. So Violet Frank has moved. Violet has spent, or Frank, as Violet's attorney, has spent the £50,000 surplus sale proceeds on paying privately for Violet's care again, and she's back down to 23,000. And Frank asks the social services to do a care assessment and a financial assessment. And unfortunately for Frank, there's been a change of care home owner. So Violet is still in the same care home, lovely care home, just down the road from his bungalow, but a new owner has taken over. And they are charging, or rather, when Violet was paying privately, it was £1,200 a week. And it's a care home that isn't registered for nursing, so she doesn't get the funded nursing care contribution, so that doesn't help. The local authority come along and they assess Violet and they say, okay, she meets the Care Act eligibility criteria, we will pay, but we will pay £900 a week, okay? And the full cost is £1,200 a week. So we've got a £300 per week shortfall. Frank's initial response to that before he comes back to see you again. Luckily, he's one of those clients that keeps on coming back to check things out. But his initial response is he's not too worried about that £300 a week because Violet gets attendance allowance and she's got a state pension, and she used to be a teacher, so she's got a teaching pension. So Frank estimates that Violet can pay £250 off that £300 gap towards her care home fees, and Frank can afford to pay the other £50. So he's fine about this. However, social services then tell him that he can't use Violet's money to pay a first party top up, okay, because the money that Violet has, the income that Violet has, £250 a week, that is included in the in the £900 that the local authority are going to pay. So the local authority aren't actually going to pay £900. They're going to pay £650 a week for the care home. Violet's income will be used, 250, to bring that up to £900 a week, and there is still a gap of £300 a week. And Frank absolutely adores Violet, they've been married a long time. He would give anything to help her stay in this care home, but he hasn't got £300 a week spare. Not many of us have. Okay, so this would be, social services are saying we need a third party payment, otherwise we will have to move Violet to a cheaper care home that does accept the local authority rate of £900 a week. Okay, we have a look at whether can Violet pay a first party top up. I've kind of gave you a spoiler alert. No, she can't. This isn't a 12-week property disregard case. She hasn't got a deferred payment agreement, loan funding against her share of the house, because the house is disregarded because Frank lives in it. The bungalow is disregarded. She was never under Section 3 of the Mental Health Act, so we can't get her Section 117. And Frank has tried lots of times to secure NHS continuing healthcare for her, but hasn't been successful in doing so. And so therefore there is none of these exceptions apply. If Violet had a personal injury award, that is disregarded. That income and that capital is disregarded in the financial assessment. So she would be able to use that for a first party top up, but she hasn't got a personal injury award. So that isn't something that we can use. So we are looking here at definitely a third party top up. And Frank is really very distressed. Violet doesn't understand everything that social services are talking about in terms of moving her, because she no longer has mental capacity to make decisions about where she lives and where she is cared for. She can express her wishes and feelings, and she likes that care home. And she loves the fact that she sees Frank every day, twice a day. Okay, so it's Frank, though, that is worried, because social services have said, look, okay, we found a care home that does accept £900 a week, so we propose that Violet moves there, and it's not in the same town, it's 2 towns along. And Frank says, but that's going to be impossible for me. I can't get there to see Violet once a day, let alone twice a day. I'm no longer able to drive because of my cataracts. And it would involve me getting 3 different buses, and I won't be able to go and visit her. Okay, so this is a big concern to Frank, and also he does not think it would be in Violet's best interest for her to move. In fact, he thinks it would be really detrimental to her well-being, even though her dementia is very advanced and her understanding is quite limited. He thinks that she would be shocked and her well-being would be damaged by the process of moving away from the other residents who she's known for many years, carers who've been working with her for 5 years plus, etc. So that's the typical picture there. So what we're looking at then is what can we do to challenge that third party top up situation, given that Frank hasn't got £300 a week, and given that, as I say on this slide, Violet's money is having to be used to pay towards the £900, and the care home have presumably turned around and said to Frank, no, we're not going to decrease. You've got to pay £1,200 or we'll have to give notice and Violet will have to leave. So what we need to do, and how we will make a difference in private client practice, is we want to show that Violet has a need rather than a preference to remain in that care facility. I'm going to call it Sunnybank. So it's Sunnybank Care Home. We're going to argue that Violet has a need to stay there. And because she has a need, the local authority, social services, should increase their budget that they are using for Violet from £900 a week to the actual cost of £1,200 a week. Violet still pays her £250, and no third party top up is required because Violet has a need to remain in that care home. Now, how are you going to argue need in this case? So we get an awful lot of top-up inquiries from our clients, and they will often be related to the fact that in the beginning, the person with care needs or their family or their attorney or deputy chose what's called a more expensive care home. And so you can imagine that social services are going to want to resist the argument that they have a need to remain there. You'll be really wanting to get some medical clinical evidence of the harm to Violet's well-being if she were moved to a cheaper care home where her husband would not be able to see her once a day, let alone twice a day. But we dig into the things that Frank has told us in order to run our argument that Violet has a need to remain at Sunnybank Care Home. So it isn't that Frank needs to visit Violet. It is that Violet needs to be visited by Frank. That is her need, not his, because social services don't have to take into account what Frank wants or what Frank needs. They've got to look at Violet's well-being, and that is part of the care act. They have a duty called the well-being duty, and they also have a duty called the prevention duty. And if they move Violet, it will not be preventing a deterioration in her health. It will probably precipitate a deterioration in her health, and it certainly won't be meeting her well-being needs. So what we do is we discuss with Frank what happens on those visits that he makes twice a day, and we find out that what he does is he goes in at lunchtime and then he goes in at tea time. And the reason that he does that, although the care home staff are absolutely lovely, they're run off their feet and they do not have time to sit down with Violet to ensure that she eats her full meal. And Violet, because of her dementia, is very forgetful. She's easily distracted. She might take a mouthful and then just not eat anything else unless there's somebody there with her, helping her, prompting her to lift her spoon and fork and to eat her meal. Alternatively, if left unsupervised, I've had quite a few cases like this, Violet may eat too quickly and then has a risk of choke risk, which could be dangerous or even fatal. So the main meal is at lunchtime, and Frank sits with Violet and ensures that she manages her whole meal at a slow and steady pace, and then they spend some social time together. And then the tea meal, the evening visit, is more of a snack, but again, he is facilitating her safety and her well-being and her nutritional needs. So we are arguing that you have to be quite careful in your arguing, because you really don't want social services to be running a safeguarding investigation against the care home for not having sufficient staff to supervise supervise the eating, but you choose your wording well, and you argue that Violet has a need to be visited by her husband twice daily, and that won't happen if she is moved. And you also talk about their Article 8 rights as a couple who've been together a very long time, married or not, doesn't matter. Their Article 8 rights to family life. And if you succeed in those arguments, we are showing that Violet has a need, not a preference, to remain in that particular care home. And then, as I say, there should be no top up, because the local authority should agree that the correct personal budget for Violet is in fact £1,200 a week, not £900 a week. She pays her £250. The local authority pay the rest, and there's no top up. Sometimes you can come to a compromise position. I remember a case I had a few years ago where, unfortunately, before taking advice, the family had knowingly chosen a very expensive care home, where the funding gap was £210 a week. They chose it knowing that there was only 4 rooms in that care home at which local authority funded residents could be placed, and knowing that none of those rooms were free at the time that Dad moved in, and also knowing that he only had sufficient savings to fund 6 months worth of privately paid care fees. So within 6 months, there was a dispute with social services, who were saying that they would move him, and social services did a really, really clever job here, because they found a cheaper care home very, very close to the original care home. And they also said that they would, and for a period of time, they would pay for taxis for this man's wife to get to visit him at the new care home. And they were also suggesting a phased move. So he would start with doing 1 hour visit twice a week, and then he would go for 2 afternoons, and then he would go for 1 night, and he would have a trial to see how it went in terms of him moving, so that his well-being needs were met. But the family was still opposed to the move, and they did not have £210 a week between them in order to fund the gap. And what we had there was a best interest meeting, actually, which kind of came out of best interests and started being more of a round table meeting, at which it was agreed to split the difference. So I'm not sure that it was the best use of the Mental Capacity Act, or indeed of the Care Act, but it worked for the family. And the lawyer for social services put forward a suggestion that social services would increase their payment by £70 a week. The care home would decrease the charge by £70 a week, and my client's family would between them fund £70 a week. So those 370s reached 210, which was the top up figure, and that was agreed as acceptable, and he was able to remain living where in the care home. So, as I say, even at the time that I was in the meeting, I was thinking, oh, I'm not really sure about this, but it worked, and it's what my clients wanted. So that's what we're left with. So factors that may be relevant to arguing that someone has a need and not a preference to move or remain in a more expensive care home: specific religious or cultural needs. The Ombudsman, I will put these into the footnotes for my slides, actually. The Ombudsman has recently published 2 reports which were about cultural rather than religious needs for adults, now elderly, who had grown up in the Caribbean. There were care homes that would reflect their Afro-Caribbean culture, but they cost a little bit more. And so the Ombudsman has made it clear that cultural needs are relevant. We have a very lively case at the moment where our client has, her family say, has religious needs that can't be met in a non-faith-based care home. We'll see how that goes. We also have another issue. It could be a need rather than preference. It's one of the things that makes me most cross, that even in 2024, Health and Social Services continue to separate couples who wish to be cared for together, because they will say they can't. If we look at Frank and Violet again, let's say Frank loses all of his mobility, mentally absolutely fine, and he wants to be in the same care home as Violet. and social services will say no because it costs too much and he just needs a general lower cost physical health care home placement that's say £200-300 a week less. So I've run a lot of cases around the need for a couple to be cared for together, because I don't think the state should be separating people who have been together for a long time and still want to be cared for together, because the reality is they won't see each other if they're in separate care homes. It won't happen unless the family make it happen, because care home staffing doesn't provide for them to visit each other in the other care homes. So do have a look at that Windsor and Maidenhead Ombudsman report. It's very good. Another issue about need, this is relevant to Frank and Violet, the proximity of the care home to key family members. Specialist dietary requirements, that actually fits in with the religious case we've got at the moment. The older lady in question has a strict faith-based diet, which is also happens to be vegan, and it's whether an ordinary care home will be able to cater for that. A person's psychological needs may be relevant to arguing to stay in this particular care home. As I mentioned, the impact of a move upon the person's physical, cognitive or mental health may be relevant. And then there are cases in which specific physical factors are relevant. So the ones I've just chosen to highlight, the room that is being proposed for Violet to move in the new care home, if it's too small to manage her equipment, so if she is hoisted and she has a wheelchair and she has other equipment, and the room in the new care home is too small, that could be relevant. If a person has a genuine fear of using a lift and the alternative care home placement being suggested, the room in that home can only be accessed via a lift, and etc. Or actually, another really good example, we had a much younger client, and I wanted to bring us back to remembering that we act for people of all ages. A woman in her 40s who was unfortunately in a long-term care situation, and no longer had the money to privately fund it. She had been moved twice by social services. She had no health and welfare deputy, no health and welfare attorney. She'd been moved twice because, unfortunately, whilst in the younger person's care home, she had twice been attacked by other residents in the communal bathrooms. And so her social worker assessed that care home number 3 must have an ensuite shower and toilet for her, because she had become so scared of being attacked that she was not washing, bathing, showering, and it was causing lots and lots of complications. So she had an assessed need for an ensuite. Found a care home. Everybody agreed it was a good care home. She didn't have mental capacity to make a decision for herself, but a best interest decision was made for her to go there. She liked the home, and she particularly liked the fact that it had a very small ensuite shower room with a toilet. And her brother was her finance attorney. And after a few weeks, he got an invoice from social services asking him to pay a top up of £70 a week. 10 weeks had passed, so they asked for £700 because the care home was £70 more a week than the local authority said Jane's personal budget figure was. Now, that was very easy for us to resolve, because we had the best interest decision in writing, and we had the care and support needs assessment in writing, and both of these confirmed her need for an ensuite shower room, in which case there can be no top up, third party or first party. And what had happened there, unfortunately, is that communication at social services had gone awry. So having made that decision, the social worker should have ensured that the financial assessment team were aware that Jane's personal budget figure had been increased by £70 a week to cover the cost of the ensuite facility, therefore no top up would be required. So I hope that's useful. There's some other points you can consider when you're arguing against the top up, and in here at the bottom I've given you the parts of the Competition Market Authority Consumer Law Guidance for Care Providers, which is specific to top-ups. It really is a great read, and that's whether these are social care top-ups or NHS continuing healthcare top-ups, which shouldn't be allowed. And then I will, when you receive a copy of the slides, you'll have a few ombudsman decisions, but this is one of the most recent ones. Very interesting, just reminding local authorities how they're supposed to be conducting themselves in a top-up case. So in this case, Mrs. X went to a care home for respite. The local authority funded it because she owned her own home, but it was a temporary placement. And she went there because her package of care at home had failed. The home was local and her daughter chose it because the local authority didn't suggest any placements. The local authority told her daughter that if the placement became permanent, the rate that they would use would be £558.94, 558.94 per week, and that would be applied during the 12-week property disregard period. So after the 12 weeks, Mrs. X would be privately funding her care anyway, but during those 12 weeks of a permanent placement, the value of her property is disregarded and she doesn't have any other significant cash. So social services are paying for 12 weeks. And they said, social services also said, so Mrs. X's daughter, you're going to need to find £353.06 per week as a top up for those 12 weeks. That was all at the beginning. A best interest decision was made for her to remain at the home on a permanent basis. And the council then tried to collect from Mrs. X's daughter this significant sum for the 12-week property disregard period of almost £400 a week, which she didn't have. She complained, the council didn't find, she complained to the council and they didn't find any fault on their behalf, so she went to the Ombudsman, and the Ombudsman found fault with York City Council because they hadn't offered Mrs. X a placement that was within her allocated personal budget figure. So what the Ombudsman was saying was that if they wanted to be able to justify a top-up as being lawful, the local authority would have had to offer Mrs. X a care home placement suitable to meet her needs and available with a vacancy at the cost of £558.94 per week. And they would have to do that and show that it was genuinely available. And if they did not offer her a placement within her personal budget figure, then a top-up cannot be charged. So in this case, the recommendation given by the Ombudsman to York City Council was that they should cancel the top-up charges. So Mrs. X paid from her income towards her placement, but her daughter didn't have to pay a top-up. It's quite a discrete case because it's only about 12 weeks, but why I've brought that one to you is if you do go onto the Ombudsman website and you pull it down, it's got all of the law and guidance really beautifully packaged in the decision and really easy to read. Okay, so we're going to look at a case of care at home and getting adequate funding for care at home, and then we're going to look at deprivation. Okay, so paying for care other than in a care home can be really contentious. Again, many of our clients will self-fund their care at home for a long time because they live in their property. The value of their property is disregarded in the financial assessment, and so how do they remain at home when they can no longer afford to privately finance it? And the big issue here is that local authority, health and social services use arbitrary ceilings and will issue statements that are legally wrong, but our clients don't realise they're legally wrong. Sorry, I've got a slide with some of those statements on, so I just want to pull that slide up because that would be more useful. Here we go, fake news. The kind of things that social services or health may say to our clients or to their families when they ask for support for the person to stay at home. We do not pay for 24/7 care at home. You'll have to move to a care home. We never provide nighttime care. You'll need to move to a care home. The maximum we pay for is 4 care visits a day. Or it won't be safe for you to stay at home. There are too many risks. You'll need to move to a care home, or you should get an equity release loan or a deferred payment agreement to pay for your care if you want to stay at home. These are all things that our clients in my team have been told time and time again. Maybe not all 5 of them in the same case, but you know, it is all fake news. In terms of the first 3, those are blanket policies, and if you dig back into when you did public and administrative law when you were at law college, you'll know that a blanket policy as a matter of public law is unlawful because it means that the health or social services are fettering their discretion. So you would challenge these top three. Number four, it may be correct that there are too many risks and it's not safe for the person to stay at home, but that needs to be individually assessed, okay, and very, very robustly assessed, and ways to improve safety looked at before we do something as restrictive as effectively enforce a move to a care home. And telling a client that they should get an equity release if they want to fund care at home. I mean, it's an option. They can do it if they wish, but they shouldn't have to, because the value of their home should be ignored. So I have got a case study on this one, which hopefully will resonate with you. I've changed all the names, but these are one of my cases from just a couple of years ago. So Alison is professional deputy property and finance for a number of clients, including Beatrice, who's 88. She's got Alzheimer's disease. She lives at home in the southwest of England, and she requires around-the-clock supervision, so she's got 2 living carers to support her. Beatrice is a widow with no children. She inherited significant sums from her late husband, but over the past 10 years, almost all of her savings have been used up paying for care costs and living costs. She's got £30,000 of savings left, and her home, which she owns. Alison is very, very skilled professional deputy, and she goes to the local authority in advance, in very good time, to ask them to assess Beatrice, care and support needs assessment and a financial assessment, so that Beatrice doesn't run out of money to pay for her carers and her living costs. So the first thing the social worker told Alison is that social services don't provide living care packages, which, as I said, that's a blanket policy, and if it is actually their policy, it is unlawful. And the social worker said, look, she owns a house. She should get equity release to fund the care costs, or else Alison could move Beatrice to a care home and sell her house to pay the care fees. So Alison knew that this wasn't sounding right. She did, in fact, make an application to the Court of Protection for permission to seek an equity release in case she ever needed it, but she hasn't acted upon that permission. So she's got that permission just in case it's required. So when advising Alison as part of your best advice practice, you go through a fact-finding process with her to build up the arguments that it's in Beatrice's best interest to remain at home. So these are the kind of things that you find out, or I found out in my case. Beatrice's main carer has been with her for 9 years, and she is crucial to keeping Beatrice settled. The reason that we know that is because 2 years previously, Beatrice's carer had to take some time out to have a medical operation. And Beatrice went to a care home for respite whilst her carer took time out. But the care home placement was absolutely disastrous. Beatrice was so distressed. She was trying to jump out of first floor windows and smash doors. She was really hugely distressed. She could not cope being away from her home. And it was so disastrous that social services initiated a safeguarding inquiry to protect Beatrice, to get her back home. And social services made a best interest decision that Beatrice should be cared for at home with 2 carers, so that there wasn't so much carer fatigue for the one main paid carer, and that the deputy should use Beatrice's money to pay for this package to keep Beatrice safe. So that best interest decision doesn't bind social services forever and a day. We have to look at the circumstances at the time, but nothing had changed for Beatrice. So whereas when Beatrice had the money to self-fund, social services were happy to say it was in her best interest to remain at home. Now that she no longer has the money to self-fund, they're saying, well, she can go to a care home. And they want it both ways. So Alison instructed me to help her in my first challenge letter, because I had to write 2, to the local authority, reminded them of their earlier best interest decision and the fact that nothing had changed, apart from the fact that Beatrice now qualifies for local authority social care financial assistance. It also reminded social services of their duties under the Care Act to assess Beatrice's needs, draw up a support plan, and set a personal budget figure sufficient to meet Beatrice's assessed needs. So what my challenge letter, it wasn't a pre-action protocol letter, actually, it was a very formal, strong letter. That resulted in social services offering Beatrice a personal budget of £700 a week. So we did assess her needs, and they said, we can meet her needs in a care home for £700 a week. So we will pay £700 a week towards her care at home, and the deputy can get the rest from an equity release. So the actual cost of Beatrice's care package fluctuated between £1,700 and £2,000 a week. So we were very much short in terms of being able to fund that unless there was an equity release. So I wrote a second challenge letter to social services in Beatrice's case, at this point quoting to them from the law and guidance about arbitrary ceilings, and saying that it is unlawful for them to set the amount of Beatrice's personal budget for her social care needs with reference to a care home. That is not what the law allows them to do. So quoted chapter and verse, copy, cut and paste, and etc. And here the local authority were really sensible, actually, because in my second letter, I said, can you please allocate an experienced social worker who knows what they are doing so they can reassess Beatrice's needs and arrive at an adequate personal budget figure for her. And they did allocate somebody very sensible who did know what she was doing. And this new social worker increased Beatrice's personal budget figure on the basis that even if in a care home, Beatrice would need one-to-one support for at least 4 hours of every day, and possibly more than that. And that Beatrice had quite extensive needs in relation to her nutrition, because Beatrice used to be a professional chef, and she couldn't stand to be left out of her own kitchen. So meal preparation was something done with her and the carer. And again, for that to be replicated in the care home, it would add additional cost. And there was another reason. Oh, she had quite intense continence needs as well. So basically, the social worker rejigged the budget, and instead of it being £700, the social worker came back and said it should be £1,400 a week. And that's what the social services were offering to pay for Beatrice's care at home, leaving a shortfall, but still a shortfall. So leaving her £300 to £700 a week short. The deputy in that case decided to accept the local authority's offer. So we could have threatened judicial review. We could have gone to the ombudsman, but the deputy felt that we had pushed as far as she wanted to, and made a best interest decision to accept that funding contribution from social services and to secure the gap from the equity release, which she had permission to gain. Really, really vital if you're going to do anything like that. Only do it after you've explored as far as possible what is the maximum health and social care funding you can get. But then also, if it's a social care case, make sure that you have a written agreement with social services that they will ignore the equity release funding that you have released, because otherwise you're going to make Beatrice a self-funder again. Because let's say you take down £50,000 of equity in order to top up, you want to put it into a specific account, perhaps it's called social care top-up account costs only or something like that. If you don't have social services agreement, they'll run away laughing, because they'll say, well, we were going to pay £1,400 a week, but you've just put your client back above 23,250, so she's a self-funder. Okay, so deprivation, which is an issue that comes up fairly often, and I will be leaving you to read into some of this, but saving the family silver. So if we go back to the beginning, if we look at the election campaigns, if we look at the media coverage of catastrophic care costs or very high care costs, the reality is that what many families are doing is transferring and gifting capital and assets at an early stage in order that it is no longer available to pay for the care. And that's deprivation. And this might be done, it might be done intentionally, and that's relevant to what we're talking about. It might be done unintentionally. Often it's done very clumsily. So we're getting a lot of cases at the moment about multi-generational property ownership, where mum and or dad and adult child have invested in a property together, but the parent's name is not on the property. And then the aim is that the parent stays there for the rest of their life, but something goes wrong, and they then move into a care home. they no longer have any savings or any assessable assets because it's been invested into this property, and they don't have a deed of trust over that property, and their name isn't on the legal title. And the local authority are going to have a look at this and probably argue that it is deprivation. So the factors the local authority needs to consider when deciding if there's been deprivation are whether avoiding the care and support charge was a significant motivation when the gift or the transfer was affected, the timing of the disposal of the assets. So at the point that the capital was disposed of, given away or transferred, could the person have had a reasonable expectation of the need for care and support? And then the third part of the test, did the person have a reasonable expectation of needing to contribute to the cost of their eligible care needs? I think C, the test at C, is really very, very simple, because it is in the media so often that I think everybody is aware that you have to pay for your care unless you get one of the very rare types of fully funded care. And I've known plenty of families try to argue, again, going back to the first half of this session, oh, but I thought the fast track funding was for life for my mum. I never knew she'd outlive it and she wouldn't die, and that's why we gave her property away. That's not going to be accepted as an argument by the local authority. And in fact, I had one case last time round. The care cap was supposed to be coming in when I'm trying to think who was in charge then. I think it was Theresa May. A client came to see us having given away everything that she owned apart from £86,000. She very, very much had mental capacity, absolutely. So she sold her flat, gave everything away, kept £86,000, moved into a retirement home, used her £86,000 to pay for her retirement home costs, and then asked social services to help. And they said, well, no, we're not going to help because you've given away a property worth £300,000 and you've given away savings and investments and ISAs. And she said, but I was acting in reliance on the government manifesto and promise, which was at the time, I think it was the £83,000 care cap. In any event, she was acting on the manifesto promise, and it's 82,000. Sorry, and the local authority said, "Well, you shouldn't have done it. We still consider it to be deprivation," and the Ombudsman found against her as well. So I mentioned focus reports earlier, really, really good Ombudsman focus report. It is a couple of years old, but it's still absolutely worth reading. When you get the links, you will be able to access. When you get slides, you'll have the link to have a look at it, and it tells you what local authorities are getting wrong in terms of deprivation, in addition to what our clients are getting wrong. So what I'm going to do is just take you through in our last 5 minutes before we start for questions, just a few examples of deprivation cases. So paying family for your care. This is one of our cases. And what happened was Mrs. B owned a property with one of her daughters, fell out with her, and decided to sell. The sale was delayed because the family had fallen out, and Mrs. B moved into a luxury annex at her other daughter's, Miss C's house. Because Mrs. B didn't have any money, she was going to get lots of money from the sale of the house, but she didn't have any liquid cash. So her daughter C paid for her mother's care, private physiotherapy, disability equipment, motability vehicle, all sorts of things. When Mrs. B, mum, received the sale proceeds, she paid £140,000 of that to C, to her daughter, and she got it all done by a solicitor properly. And the solicitor's letter said that this was backdated payments of £2,000 a week for all of the above costs, including care. A few years later on, Mrs. B runs out of money and has moved into a care home, actually. And the local authority said that there was a deprivation, and that £2,000 a week was far too much for Mrs. B to have paid to her daughter, and it would only allow between £150 to £450 a week. So therefore her daughter would have to give the money back for her mum to pay for her care fees. The Ombudsman was really critical of the local authority assuming deprivation, and there was actual evidence that C had spent this £120,000 on her mother's care and other living costs. So the local authority was directed to go back and think again, do another financial assessment. And because that's our case, I can tell you that we know that they decided that time that it wasn't deprivation. Another case that wasn't deprivation is where a couple, one of whom had healthcare needs, gave some money to one of their sons to help him buy his lease, extend his lease. And the local authority said that is deprivation. And the Ombudsman said, no, it isn't. So that was quite helpful. Another situation of gifting, Mr. and Mrs. X had helped 3 of their 4 children with lump sums to purchase a home. The 4th child didn't need that help because she lived in tied accommodation. Several years later, she lost that tied accommodation, she lost the job, and so they equalised and they wanted to let her have the same amount of money. But Mr. X, her father, had developed care needs. The council said the gift to her was a deprivation, and the Ombudsman found fault in the process, recommended an apology, and that the council should review the decision. We don't know what happened after that. Having said that, we've got lots of cases where equalising between adult children, the Ombudsman has said, yes, that is deprivation. So we can't, each case turns on its own fact. This one I think is really important. It's an old one, but it's important. Cornwall County Council, we're going round telling all people who have been self-funders who then qualify for local care funding that the most that they were able to spend of their own money whilst they were privately funding their care was £24.90 a week, and that spending above £24.90 a week from their own private income was a deprivation. Absolutely not. There's quite a detailed, and this is a case of ours, again, another case of ours, where a woman paid back her son money that he had loaned to his parents years and years and years ago to help them buy a house, and but there was no paperwork, and we had no reason not to believe that everything stacked up, but there was no paperwork. That was a big problem. So she paid him £100,000, and she was fit and well. She was of age, but she was fit and well at the time. The council said it was deprivation. We used the council complaint process. They wouldn't back down. We took it to Ombudsman, and the Ombudsman was very critical of the council, who did then withdraw the decision, because the Ombudsman would basically say, the council basically said, look, your mother was nearly 90. She should have known that she would end up with care needs. Her care needs developed after a completely unanticipated fall and were not predictable, and essentially that's age discrimination. Okay, there are some slides around how you manage disputes with health and social services, and there are some slides around end-of-life care planning, and that's really just to bring your attention to fast-track funding from the NHS. I will make sure that those are circulated to you, and I will pause now because I think I've used up 2 hours, and have we got any questions from anybody?
Kate, Paul's commented, this was about 4 minutes ago, surely if deprivation is avoided, even if deprivation is avoided, the transferred asset might be added to the person's estate and be subject to IHT.
Yeah, but I mean, thank you, Paul. I'm not a private client lawyer. I'm sorry, I should have said that at the beginning. So I'm a community care lawyer. I'm a public lawyer, so I don't deal in IHT. But yes, I think you're absolutely right. And one of the problems why our clients think that they can do all of this gifting, even when the adult has got care and support needs, the adult who donor, if they're making that decision for themselves, we normally find it's adult children making the decision, not the parent, is they say, oh, well, it's the 7-year rule, isn't it? So long as mum does this and then survives for 7 years, social services can't ask for the money back. The inheritance tax 7-year rule does not apply to social care funding, which is really, really important. But yes, thank you. Good point. Gifting can have many consequences, as can multi-generational property ownership. Brilliant idea. You know, I know lots of people are doing it as a result of the shock that came through in the pandemic, but you could fall out with the people that you've moved into and moved in with. And one of my biggest deprivation cases, in terms of the angst that it caused to my clients, not in terms of the value. The mother's sale proceeds were used to buy a house in the countryside where she would live with her daughter and son-in-law who had been living in France. She, I think, contributed 80% of the purchase price. They contributed 20%. The conveyancing solicitors didn't advise a declaration of trust, advised them of the fact that the brothers might bring a claim under the Inheritance Act 1975 after mum passed away because her name was not put on the title, decided that mum had mental capacity without meeting her, which was quite bizarre, but she wasn't on a legal title, nor was a declaration of trust. Really quickly on this, because it is important around deprivation. She went into a care home for 2 weeks because she didn't want to do the physical move with her daughter and son-in-law. And so she went into a care home for respite. She had dementia. She liked the care home. She really liked the care home. When she came home to her new property that she had wanted for years to live in the countryside, she decided that her son-in-law was an absolute pain and that she could not tolerate living with him. And so she had mental capacity. She made a capacitated decision to move back to the care home where she loved it, where she loved living. And that was a deprivation for lots and lots and lots of different reasons. And actually, interestingly, the case was settled. So the family ran a professional negligence claim against the solicitors who had helped with the conveyancing process, and the insurer paid up. But yeah, that could have been, they might have had to sell their property, and there we are. Anyway, sorry, I'm digressing again. Any more questions, Helen or Louise?
I can't see any at the moment, but remember, you can raise your hand if you'd like to be unmuted and talk directly to Cate, or if you are intending to ask a question. Oh, Paul has raised his hand, so let me just see if I can make this technology work. There you go, Paul. I believe I've allowed you to unmute and also to put your camera on, hopefully.
I'm waiting to see if I can see anybody.
Just Paul, can you hear us? You'll just need to unmute yourself if you are unmuted, but we can't hear anything from you. Sorry about that.
Is that better?
Yes, we can hear you now, Paul.
Right.
Hi, Paul.
Well, since my question, across my inbox has come, guess what? A psychiatrist assessment of the question I asked you about half an hour ago.
Oh.
And what it says, I quote, "There is no evidence of prominent cognitive impairment. Any learning difficulty or disorder is like borderline." In the face of that, I think the power cannot be used.
I think you're right.
And therefore, I've now, apparently there's a complaint made about how the attorneys was being used. And the story is going on as I speak, but basically what's happened is the patient wrote a letter, he's in care, wrote a letter asking the bank for some money. The bank said no, demanded to see the power of attorney. It was sent, and they wouldn't accept the patient's letter, wanted the attorney who can't use it to sign the letter as attorney to get the money out. You couldn't make this up.
No, and you're actually, unfortunately, in this case, Paul, it's failing at the first hurdle, because on the diagnostic test, the psychiatrist is saying there is no relevant diagnosis. And then as a welfare lawyer, because a lot of the work I do is in the Court of Protection for Health and Welfare, I'm beginning to sit here and ask myself why the person is even in a care home.
Well, in this case, I've turned around and said, look, because the power is like this, you have no authority whatsoever to answer the OPG's questions. You haven't got it. The only person who can answer the questions is actually the patient.
But has the person, we have to be so careful with OPG investigations, haven't we? Has the attorney actually been trying to use the power of attorney document?
What they did it on 2 letters when the bank insisted they wrote a letter like this, or they wouldn't pay for his care.
Okay, so
it.
I think that the attorney does need to answer the questions in a really limited way.
Well, she has said, I can't do it because I don't have any powers. And in fact, interestingly, I was told that the care home also refused to answer the questions.
Oh, right.
Because they turned round and said, said, hang on, we can't do this.
Yeah.
And they've said, we can only give you the information you want if the patient agrees that we can release it. Right. And I think the care home is right.
Well, yeah, I mean, and if they have capacity and they don't want their information sharing, if we just pause
very odd.
It is odd, but if
I don't think on the face of it they can, and they've turned around and said, well, he's not cooperating. What they should do, what the OPG should look, what they could do, they could say, look, we're quite happy to get this information, provided the patient agrees we can release it.
But yeah, you've got data protection, you've got all sorts of things going on there. But my thinking is this, Paul: if P does want his attorney, you trust the attorney and wants the attorney to work with them and support them, then aren't we better that P revokes that lasting power of attorney and makes a new one without restrictions on it?
Well, I suspect what the OPG will do, they'll seek to have the LPA discharged and then appoint a deputy. Well, that's interesting of itself, because if there's capacity, the Court of Protection doesn't have any jurisdiction, period. And I'm tempted to go back and say, we oppose this. Given the terms of this power, we do not believe you have any jurisdiction to hear this application. Bang, and leave it as short as that.
Yeah, but you can't, if P doesn't agree, you can't even send the doctor's report, can you?
Let me just check. Yes, I think we can, because it's been addressed to the attorney.
Okay, all right.
So
okay,
if it's been
interesting
addressed
stuff.
like that, I think they can turn and simply say, sorry, you have no jurisdiction to hear this application.
You can give it a go. Yeah, you can, if yeah. You can
well, the misfortune that the OPG have is that I'm a trained forensic bank inspector, which is going to make their life very difficult when I start asking questions. And I'm told of all the people who hated dealing with, I was the inspector they feared the most.
Right. Useful skill.
I have the pedigree to take them on.
Useful skill. Well, it's yeah. I mean, if he's got mental capacity, and
well, I would have said on that wording, he's got capacity with help under Section 2 of the Code of Practice, with support to make any decision he needs to make.
Yeah.
And provided, and they're quite clear, you can't assume capacity, and capacity is not to be assumed if with help he could make the decision.
Yeah.
But the OPG's on weak ground if they think he hasn't got capacity.
Well, they haven't seen the psychiatrist report, so you'll need to send that in. And
that's got to go in on a COP24. No question about that.
If you're fortunate, that will bring it all to an end, and then there won't be any proceedings. You certainly don't want to allow COP proceedings for the power of attorney to be revoked.
Well, I'm going through it. Apparently, he has said he wants the arrangements to stay in place. Now, the court will listen to that.
Okay, but I'm just going to speak over you very briefly, Paul.
There you are.
To say we have a lot of OPG disputes in my team. It could be helpful if some limited answers are given to the OPG that closes the dispute down, rather than pushing it into the Court of Protection, where months and months of people's lives will be wasted and huge sums will be spent litigating it. So if there is a way that P and the attorney can get together and say, look, here is the doctor's letter, P has got capacity, we think that ends your investigation, but let us know if you say not.
One other idea, and that is to ask the relatives to go to the home, let them speak to the patient, speak to the resident, and ask them whether he will agree to them seeing the home's record of the money they've received, if that's what the argument is. And if they will give them the information, yes, you can do that.
Yeah, I don't know. I think we probably need to take this conversation offline if you want to have a formal advice about it, because it's getting quite complicated. But what I'm trying involved with the OPG, that is way and above preferable to months of litigation in the court of protection, which might result in the attorney being removed. So if it's possible for the attorney to say, P has agreed, I did 2 letters, that's all I did because the bank made me do it. You know, give a rational, factual explanation, send in the doctor's report, and ask the OPG to close down their investigation. That would be my way forward with this one. Okay.
Thanks, Kate. I'm just conscious of time,
yes.
And it's obviously 8 minutes past. I'm sure, Paul, maybe if you had further questions, if you wanted to send them on to Eloise or I, then perhaps we could forward them on to Kate for her to look at in more detail. And if anyone else has any other questions, speak now or forever hold your peace, or raise your hand. Otherwise, we'll leave it for today. We'll circulate the slides with the recording. That will be hopefully before the end of this week. And hopefully you'll be able to fill in the feedback forms for us as well. But nothing left to say. But thank you, Kate, so much for an insightful session. And hopefully we'll see you again soon.
I hope so. Thank you for inviting me. Have a good afternoon, everybody. Bye.
Thanks, everyone. Bye-bye.
Bye.